Hey everyone, welcome back to FE1 Made Simple. I'm Jessica, and today we're diving into a really focused and often overlooked topic in equity, Cypre jurisdiction. Now I know the name sounds intimidating. It's French after all, but this is actually a very manageable topic. And more importantly, it shows up regularly alongside charitable trusts and non-charitable purpose trusts, especially in problem questions. So what exactly is the doctrine of Cypre? Well, when a valid charitable trust becomes impossible or impracticable to carry out, maybe the charity shuts down or the original purpose just doesn't make sense anymore, the court can redirect the gift to another charitable purpose that is as close as possible to the donor's original intention. As the case law reminds us, Smith says this doctrine lets the court give effect to charitable aims as close as possible to the donor's intention. And Keene supports this by explaining that Cypre ensures the donor's intentions aren't frustrated by altered circumstances. But, and this is key, Cypre only applies if there's a valid charitable trust to begin with. If the trust is invalid, we're dealing with a resulting trust situation instead. Let's now turn to the two situations where Cypre might apply: initial impossibility and 2. Subsequent failure. We'll start with initial impossibility in the next segment. See you there. Welcome back to FE1 Made Simple. Let's get into the first key scenario where the Cypre doctrine might apply: initial impossibility. This arises where the charitable object never comes into existence, or has already ceased to exist by the time the trust is meant to take effect. In those cases, the gift can only be saved if the donor had a general charitable intention, not just a specific one. Let's look at the case law. In Re Reimer, a testator left money to a specific seminary, but the seminary had already shut down. The court said, no general charitable intent here. It was all about that specific seminary. So the trust failed, and the money went back to the estate. Contrast that with Biscoe v. Jackson, where the gift was to a soup kitchen and hospital. Although those exact projects couldn't proceed, the court found a general intention to support charitable relief. So, Cypre saved the trust. A particularly exam-worthy case is Re Harwood. The testator left money to two peace societies. One never existed, and one had dissolved. The court allowed Cypre for the non-existent one. There was a clear charitable aim, but not for the other. You should also know that in Ireland, Reworth Library applied Cypre, where a hospital no longer existed. Keene J. emphasized that the gift was for the charitable function of the hospital, not the institution alone, so Cypre applied. Bottom line for initial impossibility: the trust only survives if the donor's overall intention was charitable, even if the specific object fails. Next up, we'll look at subsequent failure, where the trust has already started but fails later on. Stay tuned. Welcome back. Let's now look at the second key scenario: subsequent failure. This arises where the charitable trust has already taken effect, but it becomes impossible or impractical to carry out the donor's wishes after that point. Now here's the crucial difference. Unlike with initial failure, you don't need to show a general charitable intention. The trust was already valid, so Cypre can kick in as a remedial mechanism to preserve the charitable benefit. Let's look at a few examples. In Smith, the gift had already vested when the charity later failed. The court applied the Cypre doctrine. No need to second-guess the testator's general intent, because the trust had already been effective. Then there's the important historical example: Re Royal Kilmainham Hospital. The hospital was created to support retired soldiers, But with the emergence of the Irish Free State, its original purpose no longer applied. The courts used Cy Pres to redirect the trust funds to the defense forces, staying as close as possible to the testator's original purpose. Also note, Reworth Library, again. Here, Keene J. used Cy Pres when the original charitable institution, a hospital, had closed, but the charitable purpose could still be carried on in a different form. So, just to recap, with initial failure, you need general charitable intent. With subsequent failure, no need. Cy Pres applies automatically to preserve charitable utility. Coming up next, statutory intervention and how legislation has made it easier to apply Cy Pres in modern times. Welcome back. So far, we've talked about initial and subsequent failure in the Cy Pres doctrine. Now let's explore the statutory intervention that's broadened its application. Specifically, Section 47 of the Charities Act 1961. Traditionally, under common law, Cy Pres could only be applied if the original gift became impossible or impracticable. But this was often too rigid. What if the gift simply became inefficient or no longer appropriate in a modern context? That's where statute stepped in. Section 47 provides that the Cy Pres doctrine may apply where the original terms of the trust have become difficult to implement. The original purpose is no longer necessary, suitable, or effective. This reflects a more pragmatic and modern approach, allowing the courts to better respect the donor's underlying charitable intention. Let's look at how the courts have applied this. In Re Royal Kilmainham Hospital, which we mentioned earlier, this flexibility allowed the court to redirect surplus funds to a related charitable cause, the Irish Defence Forces. In representative church body Fraternity General, books donated for a specific use in a library were no longer serving that purpose. The court allowed them to be sold, and the proceeds redirected to church maintenance, still within the spirit of the donor's intent. This was echoed in Reworth Hospital, where although the hospital had closed, Keene J. accepted a Cy Pres scheme to redirect the funds, rather than letting the gift fail outright. A more recent and emotionally charged case is Doyle V.A.G., involving a trust for a child with a rare disease. When the child tragically passed away, the court refused to let the funds be donated to unrelated local charities. Instead, it directed the money towards establishing a specialist clinic for the disease, keeping a close link with the donor's original purpose. So what's the takeaway? The statutory regime in Ireland gives the courts broader discretion to preserve charitable gifts, even where circumstances have radically changed. But at every stage, the court must remain faithful to the spirit of the donor's original intention. That wraps up the Cy Pres doctrine. Before we finish, let's review key exam tips for the Cy Pres doctrine. First, know the distinction between initial and subsequent failure. This is a common area where students lose marks. Remember, if the charitable purpose fails from the start, you must show a general charitable intention. If it succeeds initially but later fails, that general intention is not required. Second, be able to apply case law clearly and confidently. Use Re Reimer to illustrate initial failure with no general intent. Use Re Harwood and Re Worth Library to show how general intent may be inferred. Use Smith and Royal Kilmainham Hospital for subsequent failure cases. And don't forget to reference Doyle V.A.G. and Section 47 of the Charities Act 1961 for examples of modern statutory flexibility. Third, always tie your answers back to the principle that the court seeks to preserve charitable intention wherever possible, as long as there's a valid charitable trust. And finally, If you're preparing for a problem question with multiple charitable gifts, make sure to analyze each gift individually. Some may fail outright. Others may qualify for Sci Pres under either the common law or statute. That's it for today's episode on Sci Pres. You've now got everything you need to tackle any FE1 question on this doctrine with confidence. Until next time, I'm Jessica, and this was FE1 Made Simple. Good luck with the study.